Now, I'm just a simple country, small-town lawyer, but listening to Mr. Parkinson's testimony yesterday, I came away clearly from his initial testimony. He backed away from it a little bit, in fairness, but came away from it initially believing that our system does not allow due process and that it is not fair to those people who are being accused of having manipulated electric rates or et cetera. Mr. Sherman, I gathered from your testimony that I might have had the right sense.
Yes, sir, I fully agree. I have great, and let me just state, none of this is personal. Mr. Parkinson's a fine fellow. Chairman Bay is a fine fellow, but the due process people receive at FERC today is in name only. The FERC is doing everything it possible to frustrate constitutional due process requirements. And all you have to look at, Mr. Griffin, is the disproportionality between, in the current pending cases, between what the FERC is alleging as the market harm and the size of the penalties. And if I could just enter a couple of those into the record.
Please do.
In the current maximum power case, the FERC has alleged a $5 million civil penalty with zero unjust enrichment, zero disgorgement of alleged unjust profits. In the current Powhatan case, the disproportionality between the alleged disgorgement and civil penalty is 634%. In the current BP case pending before the Commission, the disproportionality between the civil penalty that's being sought and the alleged unjust enrichment is 3,500%. In the Barclays case, the disproportionality between the alleged unjust enrichment and the civil penalty is 1,300%. In the Lincoln case, the disproportionality is 1,300%. So if you just look at whether the proportionality between the alleged unjust enrichment, the alleged amount that they shouldn't have earned, and the civil penalties, it's clear there's no proportionality in the way the FERC is administering the enforcement process.
Well, and I appreciate that testimony. I was struck with just the basic principles of due process that have evolved over the years in the Anglo-American system when, I heard things like, we don't really want third parties to have to worry about Brady. In other words, information that might say the person or the accused didn't do what they've been accused of. Well, third parties shouldn't be burdened with that. That bothered me. And then the whopper of all, and the defense was, well, other people do it. I don't accept that from my children. I'm not going to accept it from the federal government, of which I'm a representative of the people, was, well, you can't really talk about settlement with the commissioners because they're part of the prosecution team because we have an attorney-client privilege with them, and we don't want that to be violated in any way. Say what? There's an attorney-client privilege between the trier of fact and the investigators who bring the case? That just struck me as abhorrent to the American legal system. Do you agree or disagree, and what are your comments?
I fully agree. The Commission is applying the wrong Brady standard. It is clear from the testimony that they are applying the post-trial Brady standard, not the pre-trial Brady standard. Other regulatory agencies, including the CFTC, rejected, as part of their process, the post-trial Brady standard over 20 years ago. This is not a new concept. On the settlement process, it's the classic case of trying to negotiate for a car. You negotiate with the enforcement staff only to be told, oh, I got to go talk to my manager. Well, we know what happens every time you go talk to your manager. And in a recent case where I asked directly to negotiate with the commissioners on a settlement, and I said I would be more than happy to have the enforcement staff in the room at the time, I was told it was against policy to talk directly to the commissioners, even though I said I would be happy to have the enforcement staff in the room at the time.
Sure, and I can understand that while they might not want to have ex parte communications with the commissioners, but if they're part of the prosecution team, it does seem kind of strange. Do you think we'd be better off allowing the commissioners to continue to have the settlement power, but just move any disputes directly to the district court where you can have a legitimate due process-filled trial?
I think that would be a very good suggestion if the Commission itself would recognize the words de novo review in the statute mean a trial. What's happening in the Lincoln case and the Barclays case now is the Commission is taking the absurd position that the words de novo review does not lead to a full trial, does not lead to discovery, does not lead to the right to confront witnesses. They're taking the position that a de novo review is essentially no different than a court review where the Commission gets deference on the record that they built in a flawed process.
Yeah.
So if the Congress would clarify and confirm the existing language means what it means, and it should apply to the Gas Act, the Power Act, the NGPA, that would help a lot.
Well, and even a simple small-town lawyer knows that de novo means you get a new one. That's what novo means, new, and that that was their defense yesterday in part was that, well, you can always go to the district court. I would think that would be a big fix if you could actually get a new hearing with all of the discovery rights that you get in
Absolutely.
the normal court
The Power
system.
Act supposedly provides for that, but apparently the Commission doesn't agree with that.
Well, I appreciate it. My time is up. I yield back. Thank you, Mr. Chairman, for this important hearing.